So you folks can hear me okay, guys, everybody? Say yay.
Yeah.
Okay.
Yeah.
Excellent. So I'm putting the conference in presentation mode. Here we go.
The conference is now in presentation mode.
Good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. Today is April 15th, 2021. This is our two-weekly community conference call every other Thursday at 12:30 p.m. You would have heard our disclaimers when you logged in. This call is being recorded and will be made publicly available. Conceal your identity if you would rather not have your name, etc. known. Okay. With that, let's begin first of all with the questions I consider to be frequently asked questions. I will answer those. Ask for your follow-up questions on the frequently asked questions. From there on, we will go on to the non-frequently asked questions. I am not sure we're going to have any time at all at the end of this call for new questions, but whatever questions follow from the discussion that we are having, we'll be happy to deal with them, okay? First frequently asked question, this is coming up quite a lot. If H1b is revoked after 1st October of the year for which it was valid, but I never used it, am I quota exempt? So let's look at the various possibilities, and of course I will invite your questions and input at the end of this discussion. Let's say I got my H1 approval in August of this year, right? The H1 is quota H1, it kicks in on October 1st. There are two possibilities. I'm in the United States, I got my change of status beginning October 1st, or I'm outside the United States, I'm supposed to go get a visa stamping to complete my H1b process. Let us look at both these situations. Okay, so the government says unless you receive change of status or you get your visa stamping, we don't consider the H1b to be complete. Now, if you look at the language of the law, that's not what the law says. The law simply says your H1b is approved. So technically, the moment your H1b is approved, you should be beyond the quota problem for the next 6 years plus, right? But the government says something and they do something different, even though they've been telling us, if your client doesn't go get their H1b visa stamped, or they don't get H1b change of status, we consider them to be still subject to the quota. We have done many cases where we were able to get H1b without a quota issue in these types of situations. So first thing is, do you need a change of status? Do you need a H1b stamp? And the answer is, if you ask the government, they'll say yes, but if you file the case anyway with any other employer, you probably do not need that. Second, this is a fine distinction. What the government says is, you got your H1b approval in August. In September, the employer who got you the H1b revoked your H1b and it was revoked before October 1st. You are back in the quota. But if it was revoked on October 2nd, you are exempt from the quota. I can't really argue against that, because that's the government's reading of the regulations and it appears to be right. And that's the thinking that the government had the last time I looked into this issue. So what is the takeaway? You might be quota exempt even without a change of status. You might be quota exempt even if you didn't get the visa stamped. And as long as your H1b survived to October 1st, if another employer thereafter filed an H1b transfer, you should be okay. And this is true even if you were sitting in India with no stamp. That, in a nutshell, is the H1b situation. Now let's look at the question that was asked. I got my H1b stamped in January 2020. Visa is good till the end of 2021, but I never traveled to the US. The US company later revoked the H1b. So if you got stamped in Jan 2020, what that tells me is that you were approved beginning October 1st, 2019, right? And if that is the case, you fall under the discussion we just had. I think you can try. You actually got the visa stamping. So you are definitely exempt from the quota. as long as the company did not revoke your case before October 1st, 2019, which is the date I'm assuming your H1B became effective. Okay. Do not use this visa to travel though. That's tricky. Why? Because I'm always concerned. Government says you can use an existing visa with a new approval. But I'm concerned, and I never do it without double checking with the consulate. If I were you, I would send them a quick email through your lawyer asking them, do I need a new visa stamp? Okay. Now there are two different situations here. The one that you are thinking is probably okay, and the one some people have done is probably not okay. What are these two situations? One situation is where you already have an approval from another company and you travel with the new approval and the old visa. The other situation is where you travel to USA using the old visa without another approval. That is bothersome. Don't do that. But if you had another approval and you have the old visa, you're probably okay. Have it double checked anyway, but the government has said that in these kinds of cases, it's okay to travel because the visa doesn't belong to a particular company. Why is the second hypothetical problematic? It is problematic because you are traveling without a job. You don't have a job in hand, and you shouldn't be using that visa. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question for me. Okay, I've got one from area code 585. Area code 585, where are you calling from?
Hello, can you hear me?
I can hear you. Where are you calling from?
Oh, hi. I'm actually calling from Bentonville, Arkansas.
Okay. All right. Do you have a follow-up question? Go ahead.
It's actually I don't know if it's related to this. I just got into the call.
No.
So
So
I'm
I'm
not sure
gonna
if it's
put you back on the general call because we are only answering follow-up questions, not new questions, and I may not have
Yes,
time
it's
for
something
new.
to do with passport renewal.
Yeah, stand
But
by.
on STEMO.
No, stand
So
by. Okay, I'm gonna try to make room for new questions, guys. We probably don't have time, but we are gonna try to do it anyway. I have another question from area code 480. 480, where are you calling from?
Yeah, I'm calling from
Sorry, from
Bakersfield.
Bakersfield, California. Yes, ma'am. How can I help you?
Yeah. So I just have few questions. Like I'm on dependent visa, so I just want to know like whether I will be getting a job.
Stop.
Yeah.
I'm only answering follow-up questions on the
Yeah.
discussion I just did. Okay. So,
All right. Okay.
yeah.
Yeah.
I have told our team to cut off the questions at 12 because if I have 12 questions, I can take new questions. Today they have capped me off at 19. That's too many questions. I just don't have enough time. But I'll do the best I can, okay? So stand by. Then the next frequently asked question is, traveling while I-485 adjustment of status is pending, returning on H1b visa, advanced parole, AVR. So AVR means automatic visa revalidation. That's the process where you don't need a visa if you are traveling to a land connected with the United States, what they call contiguous territories like Canada or Mexico. So let's say you were on F1, you got change of status to H1, you don't have an H1 visa. If AVR were not available, you would typically have to get a visa stamp to come back into the US if you travel to Canada or Mexico. But the law of AVR says no. If you travel to connected territories and your trip is less than 30 days and you don't apply for a visa and get rejected, you can actually come back on your I-94 as long as you have a change of status. So the question is, well, how does it work when I travel while my adjustment of status is pending? And let's parse it one thing at a time. Normally, if you travel outside the United States, when any application is pending, that application is deemed to be abandoned, no longer any good. Okay. So the exception is when you have an AOS, adjustment of status pending, and you have a visa like L1, L2, H1, H4, you can actually travel on those visas. But you've got to have a visa stamp. If you do not have a visa stamp, situation becomes a little murky, especially if you're not able to get a visa stamp. Your 485 will be abandoned. Okay. So can you travel on your advance parole? Absolutely. Advance parole is specifically made for that purpose. You don't need a visa stamp, H1b visa stamp or H4 or L1 or L2 if you travel on your advance parole. And the law is, if you travel on your advance parole on H1b and come back to the same job, you are still considered to be on H1b even though you used advance parole. If you go to a different job, then you are considered to be on parole and you have to use your EAD. Okay, I've had many discussions on the relationship between EAD, advance parole, H1b. It's not that difficult to understand if you go to the frequently asked questions on immigration.com. So traveling without an H1b visa, bad idea. Traveling on advance parole, no problem. If you have an H1b visa and you are coming back to the same employer, that means the visa is still valid. Actually, the same employer is more the criterion of advance parole. But if you are traveling on H1b visa and you are re-entering for the same employer, which is the easiest thing to do, rather than having a change of employers while you're abroad, I don't know how that would play out. I would have to look at the law. So these are the various permutation combinations. Traveling on advance parole, always okay. If you come back and work for the same employer for whom you left, you are still on H1b if you had an H1b going out. Traveling without an H1b visa, bad idea. Traveling with an H1b visa and trying to come back for a different employer, it could be complicated, it could be okay. Definitely needs to be discussed with your lawyers. Okay. Now let's look at the questions. And by the way, AVR does not protect your 485. I do not know of any provision in law that says if you have a 485 pending and you just travel to Canada and Mexico and come back using AVR, automatic visa revalidation, that's okay. No, I'm not aware of that. So in my view, you would lose your 485. Okay. Priority date became current. I have filed 485, 765, 131 concurrently and for my wife as well. Two scenarios, same three questions. At this moment, if we travel to our home country while AP is pending and return on the visa, will it abandon our I-485 AOS? No, it will not. If not, will it invalidate our pending 131? Yes, it will. You'll have to reapply it, and that's not a big deal. Will it also invalidate our pending 765? It should not. Government has taken the position that it doesn't, for whatever mysterious reason, it doesn't affect your 765, the travel out, but it does affect your advance parole. Scenario 2, we are eligible for AVR, travel to Canada or Mexico. None of this applies to AVR, in my opinion. I don't know of anything that protects your 485 if you try to use AVR. Will it abandon our 485? I think so. So the rest of it doesn't really matter. Everything is gone. If 485 is gone, everything is gone. *5, if you have a follow-up question on this, press *5. No new questions, just a follow-up. Okay. I have one follow-up question. Area code 770. I believe that's Georgia. 770, where are you calling from?
I'm calling from Atlanta.
Atlanta, Georgia. All right, sir. What is your follow-up question?
So, like we both have like valid age visa stamp that is valid till like next year. So meanwhile, if we travel,
good. Perfectly okay to travel.
So, if we travel, okay. So, like even though we travel through air, as because we have the valid H4 visa, that should not impact, right?
Well, what's going to happen is when you come back, you have to apply for advance parole again.
Even though for AR?
For AR? What do you mean by AR?
I mean, for the automatic revalidation, so
Okay.
we already have the valid
Okay,
visa
you know what?
stamp, so automatic revalidation, they
Yeah,
don't issue any new
so hang on one second. AVR doesn't apply to those people who already have a visa stamp because you're traveling on your visa, not on your AVR.
Okay.
In my view, AVR does not protect your advance parole. As far as I know, you can double check with the government, but this is really a tertiary matter that we don't deal with very often.
Okay.
Can AVR protect your advance parole? I don't think so. Can you use AVR if you have an H1b visa? Of course not. You are traveling on your visa. AVR is an exception to the visa requirement.
Okay. So one more thing that if we travel with a valid visa stamp outside of US and in case USCIS abandon the adjustment of status because we went out while our AP is pending, what should be our action?
No problem at all. You just file a motion to reopen. If they normally what happens is before they deny your 485, they're supposed to give you a notice of intent to deny. And they typically give you either 10 days or 30 days to respond. You respond by saying, have you ever read the law? The law allows me to do this. So back off. That's what you say. Okay?
Got it.
Good luck.
Thank you so much.
You're welcome. Okay, let's see if there's another frequently asked question here. I thought there was one more, but maybe not. Yeah, they actually put in a lot more questions than I want to handle because it gives me no time to deal with new questions. I think they have like 19 questions today. Okay, so going back to our first non-frequently asked question. These are just regular questions now. And this is also actually more or less a frequently asked, but I didn't mark it as such. It's not a big issue. The question is, these days when we file 485, we don't send in our medicals because the medicals expire, then you have to do them again anyway. The question is, my date is getting current. Can I send in my medicals without an RFE? And the answer is, in our office, we don't do that. Because it is our understanding that the government is not able to connect medicals to cases without an RFE. It's a huge organization. But 2 weeks ago, I had asked one of my colleagues, because two of our clients asked the same question, I had asked one of my colleagues to do some homework on this, call the USCIS, look at the law, brief me. She hasn't done it so far. You can double check with me if you want. But right now, I don't have any information other than that we don't normally send in medicals without an RFE. Okay. If you did, what is the big deal? I don't think it's a big deal. What you could also do is, when you go to the doctor, you tell him, please, can you give me 2 sealed envelopes? They usually give you medicals in a sealed envelope, which you send whenever you're ready to send. This way, even if one gets lost, you have the second one. But they're only valid for a certain period of time. Okay. So, my green card EAD card is getting delayed. Should I contact USCIS 18 number? Yeah, you should. If you have a receipt number, you can chat with Emma, their so-called artificial intelligence, or you can even open a service request. *5, if you have a follow-up question on this, press *5. Okay. So we have a question from area code 570. I believe that's Pennsylvania. 570, where are you calling from? 570. Hello? 570.
Rajiv, sorry, I was on mute.
No problem.
I was just posting my question. I am calling from Pennsylvania.
Okay.
So I have the follow-up question on that.
Tell me.
So you said like we can go to a doctor and get like a couple of medical certificates. So I also researched it. It was telling like that signature is valid only for like 2 months, and once we send, it's good for 2 years.
Yeah, something. I think is it 60 days or 90 days? The rule is something like this, that you have to have done the medical within whether it's 60 or 90 days before you file the papers, and once they are accepted, then you are right, they stay valid for 2 years. But if they are not accepted, then you just wait for the RFE and do it again, and then at that point submit it. So the point is, you don't have much to lose by filing it and taking a chance and see if they accept it. What does it cost to get medicals? Like a couple $100? What does it cost?
I think it's around like 400 to 500 per person.
Oh, okay. I thought it was... I did mine in 1989. It was $200 then. I think it has changed.
Yeah, the insurance is not covering, right? Sometimes it might go higher.
Okay. So yeah, I think personally I would just wait for the RFE. But I will update you guys. If you follow my social media, I update usually Facebook, I update Twitter, and I update LinkedIn, as well as our own website. If I find the information that you guys are asking about, and if we find something out that can be a solution to this problem, I will update you guys. But as of now, we don't know for sure whether they are able to connect without an RFE. Okay?
But still, if you want to do like an interfiling, that's not a big issue, right? Like a big process.
Interfiling is a word we use only to describe when you are knocking out an I-140 and putting another I-140 on top. So when you say interfiling, that means something different. What you're saying is filing my medical without an RFE. And yes, you can try, not sure if it's going to work.
Okay, Rajiv. Thank you so much.
Good luck. Okay, let's go on to the next question. So this one, Tanmay says, I came to the US when I was 17. So it's about taxes for naturalization. Well, listen, I personally think, and I don't remember exactly what the question is, Tanmay, but if you have not worked and you're not required to file taxes, there's no question of producing tax returns. So you are too young to be filing taxes. Don't worry about it. It doesn't apply to you. If you're not required to file taxes, how are you supposed to generate tax returns? Okay. Yeah, I'm not worried about it. This should not be a complicated situation. *5 if you have a follow-up question. *5. Okay. Go on to the next question. So premium processing for EB3 downgrade to downgrade of I-140. So he has tried to premium the case 3 times. Let me explain to you what the problem is. So normally government will not premium an I-140 unless they have the original PERM. The original PERM you would have submitted when you filed the first EB2 case. You don't have it any longer. But what people have done, and it has worked, is once you file the downgrade, they issue a receipt. And by the time they issue the I-140 receipt for the EB3 downgrade I-140, they have the original file. At that point, if you request premium, they might grant it. Okay. What he's concerned about, or she's concerned about, is 3 times they returned my premium processing. Is there any impact on my I-140 regular process? I don't see any impact at all. It's not like they're going to slow it down. I don't think it should be a problem. *5 if you have a follow-up question. *5. Okay. Oh yeah, there is a follow-up question. All right, let me go back to that. And this is area code 281. I don't know where that is. Where are you calling from? 281?
Yeah, hi Rajiv sir. I'm calling from Houston.
Yes, sir. Go ahead.
Yeah, I'm not the one who posted this question, but I have a follow-up question.
That's fine.
If it is not a downgrade, if it is just a fresh I-140
Right.
under EB3 category, can we still premium process it?
The only question is, do you have the original PERM?
The original PERM?
Yes.
Hello?
Yes, that's what I asked you.
Hello?
Do you have the original PERM? I can hear you fine. Do you have the original PERM?
Yeah.
Yeah, you can file it premium. That's easy then. Okay.
Okay.
Good luck.
Yeah, thank you.
You're welcome. Okay, no more follow-up. Oh, there's another one. Area code 314. 314, where are you calling from?
Yes, Mr. Rajiv, I'm calling from St. Louis, Missouri.
Yes, sir.
So the question I have is, so I'm doing the exact same thing, but not from EB2 to EB3, but EB2 to EB1.
Okay.
And I'm almost done with the petition process and all
Okay,
that
stop
stuff.
for just 1 second. Stop for just 1 second. EB2 to EB1 should not be a problem because number one, it's not a downgrade. And number two, it is not a PERM-based petition. See, EB2 and EB3 are PERM-based cases. So you could do an EB1 premium processing without the original PERM, no problem at all.
Oh, okay.
Okay.
Thank you.
Yeah, your situation is different. Good luck.
Thank you, sir.
You're welcome. Okay, so let's go on to the next one. We did that already. So this is another interesting one from Geo. Says H4 visa holder owning business outside the US. Person is running a business in home country for more than 10 years. They move to USA on H4, no EAD, no work permit. Can they continue to keep their business alive by visiting home country for 2+ months in a year? Absolutely. As long as you're not working from the US soil, you should be okay. Now, if you're working from the US soil, things get more complicated. I'm not sure I have clear answers for you. But if you are here 10 months or even 6 months and you go home for a couple of months, work there, come back, don't work here, I think that's fine. No problem there. Now, as far as income, taxes, etc., you'll have to figure that out with your CPAs and your CA in India. There is double taxation relief between India and America. You should not have to pay taxes twice. But as to what goes into the taxes where is something the accounting professionals can tell you. *5 if you have a follow-up question. *5. Okay, let's go on to the, oh, there is a question. 480 I think is California. 480, go ahead please. California, go ahead.
So for H4 visa, like, is there any possibility to study or is there possibility to get a job?
H4 holders are allowed to go to school, but you cannot get a job without an employment authorization.
Okay, so I cannot able to pursue studies?
Yes, you can study. You can go to school, no problem.
Okay.
Okay.
Okay. Okay. So, and also I have another question. So, if once my spouse got like a green card as a process, so then can I able to apply for a job?
Once you get your green card, you are as good as a US citizen for 99% of the jobs. So you can get a job.
No, sir.
Go ahead.
Once my husband got green card processed, like my husband.
Okay, so H4 EAD kicks in after a certain amount of time has passed. There are a couple of rules. So it is not going to be immediate, but after a certain time of the green card, you can also apply for employment authorization. Okay?
Okay.
Good luck.
Okay.
You're welcome.
Okay.
Okay. So Rudra says, I'm on STEM OPT, current employer and another employer filed H1b registration. So first of all, I've answered this question before. I actually even have a comment on this on my author page on the Economic Times. If you can go take a look at it. I answered that, listen, if the two companies are not related to each other at all, and the word relationship has very wide meaning, same stockholders could potentially make it related, same management could potentially make it related. So there are many ways for the companies to be related without the traditional corporate sense of relationship. Be careful. But if the companies are not related and it's totally different jobs, the fact that you have 2 registrations and 2 H1Bs is not a problem. So let's look at the rest of your questions. Company A and B both filed registrations. So yeah, you don't have a problem. You only got one company. The other status is still submitted. Can the one that's got selected file and make the company whose registration is pending as a client? I think that could become problematic. You've got to work it out with your lawyers, because that appears to be creating a relationship. Okay, because the job for which company A, the one that did not get selected, filed, and the job at which the company B is placing you are the same job. I think you have a problem there. I think it will be a duplicate registration. But I would have to study this more carefully. My snap judgment is it's probably a problem. If you don't file as company A as your end client, can I still file H1B? So if the 2 companies are not related and the jobs are not the same, and ultimately company A, the one that did not get selected in the first draw, files your H1B, I think you are fine, because unrelated companies, unrelated jobs. Okay. If I choose to go with totally different client through company B, while H1B is in process, then till what date can I continue working with company A? So that depends. Okay, your STEM OPT is good till January 2022. So you can continue working at your present job until you get change of status, okay, which will kick in on the date of the approval, typically October 1st. So typically you should be okay till October 1st unless the approval date of the H1B is later than October 1st. In that case, you can continue working till that later date. So let's say the H1B approval comes and it's effective till it's effective on December 1st. That means you're still within your OPT, you can continue working with the old company. *5 if you have a follow-up question on this. *5. Okay. So Rajesh has a question working from India, US on US payroll. I also have a comment on this. Okay. I have a comment on this in my Economic Times author page. You can find a link to that on my blog. So if you go to my blog, right on the top it says link to my Economic Times author page. My blog is on immigration.com. Okay. So I wrote an article or a comment about, can you maintain an H1B while you're in India? And the answer is definitely you can. Are you required to follow certain additional formalities? Personally, I think the most important thing is the job still open? Even if you were not on the US payroll, I think you could still come back on H1B. There are some gray areas there. Talk with your lawyers, work it out, read my comment. But I had a case, and I cite this all the time, where somebody came 2 years after their H1B approval. The situation was their project in Washington, D.C. was, I think, delayed because the DC school system had some issue. And he was working for the Indian branch of the same company. So the job continued to exist. And that's the bottom line. *5 if you have a follow-up question. *5. So yeah, I think you can do that. Oh, there is an area code 813 question. 813, where are you calling from?
Hi Rajiv, I'm calling from India. Do I need to carry any extra documents as I'm planning to travel next week?
I would carry 2 things. I would carry my pay stubs just to show that I'm getting paid, and I would carry a letter from your employer stating that the job is still open for you.
Okay. Yeah, I have those.
And I would add to it that you are actually doing it from India. So I don't think you should have any problem. This is not an unusual scenario. Okay.
Okay. Got it.
Good luck. All right.
Thank you.
Bye. Okay. Let's go on to H4 EAD. Oh yeah. H4 EAD applying for green card and traveling outside the US. I completed my 7 years in L1A. Now last 2 years I've been working on H4 EAD. Can my company start my EB1? Absolutely. You don't have to be on L1 to start your EB1 EAD, EB1 green card. No problem. You don't need to be outside USA. You are fine. You can apply for the green card now. My spouse's I-140 approved 3 years back. We have 2+ years of H1b and H4 EAD remaining. Well, you know, if you have a successful EB1 case, it makes sense to file your EB1C case now. That way, both your spouse and you will have your employment authorizations within the next 2 years. If we go out of USA for 1 year and come back, will my H4 EAD will be still valid? No. I think you'll have to apply for it again. Yeah, because the trip is too long. Yeah, I think the trip is too long. I think your best bet is the 485 along with the EB1. *5 if you have a follow-up question. *5. Area code 972. I think that's New Jersey. 972. Where are you calling from?
Hey Rajiv, this is Deep. I'm from Texas.
Oh, Texas. Okay. Tell me, how can I help you?
So Rajiv, yeah, Rajiv. So I've been working for Indian company for 15 years, and I came here on L1. And my EB1 filing got delayed, and by that time I completed my 7 years, full 7 years, nothing pending.
Okay.
Then I switched to H4 EAD. So can last 2.5 years I am working the H4 EAD. So can my company file? You told they can file.
Yeah, I already answered that. I already answered that question. What else?
Yeah. So, but I am right now on a dependent visa. Will that be an issue, or how it will work?
That's not an issue. Don't worry about how. You don't need to understand Faraday's laws of electrodynamics or electricity to turn on the light switch. Let your lawyers worry about the laws of electromagnetics. You don't have to worry about that.
Okay. So my company can file my EB1.
Yes.
And once in case when my 485 or whatever next step gets approved, I can immediately go on the EAD. Right? I don't need to have the.
Well, EAD takes time, but it's still, at least theoretically, it's immediate. It used to be 90 days after filing 485. Now they are taking longer time, but that's a good approach for you. That's the way I see it. Okay.
Yeah, because I was thinking because 7 years over, I don't have the active visa from my company. I have my spouse visa.
No.
So if you answer, I can go ahead and file the EB1.
Yeah, you go ahead and get the EB1 filed. Okay. Good luck. All right.
Thank you so much.
You're welcome. Okay. So question number 11. Missing priority date in the receipt notice is not a big deal at all. Okay. Technically, the government is supposed to scan the records and give you the earliest date you're entitled to automatically. You can open a service request, but I don't see any problem with it. The officers who review your case have your entire history. It takes 2 clicks to find out what priority date you are entitled to and give you that. Okay. So, but you can always open a service request. It doesn't hurt. It doesn't cost you anything. *5 if you have a follow-up question. *5. Oh, by the way, your lawyer already opened a service request. You can open an ombudsman's request also. Ombudsman. OMBUDSMAN. USCIS Ombudsman. Google it. You can open a service request with them. So here we have a case. Question number 12. Father and mother's name is misspelled and EAD approval for passport renewal. Okay. There is a spelling mismatch in father's name and mother's name. is it advisable to get the passport names updated to match? Oh, no. You should always get the 485 to match whatever the truth is, whatever the right name is. Okay. But I don't think it's such a deal breaker, mother's and father's name. And as far as I know, the biometrics notice tells you to bring your passport. I don't know if there's an alternate form of identity that is acceptable. I think you'll be better off just getting your passport renewed, and if there's an expedited fee, etc., get it done so you have it with you. Yeah, you should get your passport renewed. That's what I would do. And I think they do have the expedited processing, and I don't know what exactly the process is. *5, follow-up question, *5. 214, where are you calling from, 214? 214? Hello?
Hello, sorry, I was on mute. Rajiv, can you hear me?
I can hear you just fine.
Sorry, I was on mute earlier. So I was going to actually posted this question. So whatever I had mentioned in my 485 application are the correct names. Not that the names that I had in my passport are wrong. It's just that, my passport was made back in 1980, and then I didn't actually put the last name there when we were getting that passport made in India. It wasn't that.
That's not a problem. That's not a problem, because the name is incomplete, not incorrect, and I think that's fine.
It actually is incorrect at one place. Instead of double E, that's how it appears in my dad's passport, but when I mentioned it, it was I.
Okay, wait. Let me stop you. Let me stop you. See, all our names are phonetic spellings. My name is Rajiv. Okay. If I spell it R-A-J-I-V, it's a phonetic spelling. If I spell it double E-V, it's a phonetic spelling. If I spell it I-V-E, that's a phonetic spelling. I don't think that's going to be that big a deal, not in my opinion.
Oh, okay. That's good to know.
Yeah.
And would this be an issue during the GC interview, Rajiv?
No.
Just wanted to understand from that perspective.
I don't think so. I don't think so. Okay.
Sure. Thank you, sir.
You're welcome.
That's all I have.
Good luck. So, Rahul Joshi, I've talked with him several times last conference. He was concerned about somebody who had been sponsored and came and overstayed on their tourist visa. This guy has filed for a second extension before the extension request time expired. Yeah, I don't see, like I told you before, Rahul, I don't think there is any problem with your H1b. How can you be responsible for them? So this is a different set of questions. How long can the B2 holder continue waiting for the decision? And they can continue waiting until the time they have asked for in the first case. Okay, let me rephrase that. So let's say the first case was extension from January to June. The second case was extension from June to December. So if the January to June gets denied, unlawful presence begins, even though June to December is pending. But let's say the January to June is pending, and we are now in July, past the June date. Then the second case gets denied, unlawful presence begins. So they are only covered to the extent that their requested period is still in existence and the cases are still pending. Okay, this is a little bit too complicated. I'm not sure I have the time to cover everything here, but the accrual of unlawful presence begins on the denial. That's the normal interpretation, generically speaking. So there are too many permutation combinations for me to cover, but the bottom line is, if their requested stay has expired and they continue to stay, and there's nothing else pending, unlawful presence. Something is denied, unlawful presence begins. Okay. *5, and please keep your question to 1 or 2. I've got a lot of things to cover. So Rahul, I'm going to answer one question. Choose one wisely.
Yeah.
That's not Rahul.
Hello?
Who is this? Go ahead.
Yes. Sorry, Rajiv. Yeah, my name is Divya, and I have a follow-up question. My parents have been here for 1.5 years on a B1 extension.
Okay.
And we got one B1 like I-539 approval until June 2020.
Okay.
Then we filed for another I-539 in September 2020, and the biometrics was
okay.
done
1 second,
on
Divyaji. 1 second, Divyaji. 1 second. You requested an extension till June?
No, we requested, we requested extension till June last year.
Okay, wait.
Because,
Please answer my questions precisely. So you applied for an extension till June and you got it, right?
Yes.
Okay.
Yes.
But you filed for another extension in September. That means your previous extension had expired?
Yeah, so I can explain that.
No.
Actually, we made
Don't explain. Don't explain. First, answer my questions. You are asked for an extension till June. After its expiration in September, you filed another extension. Is that so far the fact pattern?
Yes.
Okay. And that extension asked for September to March?
Yes.
Okay. And that's still pending? Was it denied? Did you file another extension?
No, we had biometrics done on Feb 24th in respect of this application, which was filed in September.
Okay.
But we don't have the approval as yet from USCIS.
Okay.
And we have not filed another extension.
Okay.
But my parents are still here.
Okay.
And we can, my brother can actually file for their green.
Yeah,
green card.
This is definitely a lot more complicated than I have the time for right now.
Okay.
But the good news is, if your brother is a US citizen, none of this is going to be a problem. Okay, so be at peace. It's not going to be a big deal. Don't let them leave the United States until you've talked to your lawyers. Get the situation clarified. You're going to be fine, but don't let them travel until their green card paperwork is done. Okay.
Okay. Got it. All right.
Yeah.
Thank you so much.
You're welcome. Just to add one thing for you, what happens is parents of U.S. citizens, spouses, children, etc., can get their green card even if they have been unlawfully present for 30 years. No problem at all. And here, I suspect we have unlawful presence. But I don't think it's going to be a problem because they are parents of a U.S. citizen. Okay? Good luck. Okay, so sexual orientation. This is an interesting question. First of all, I don't know anything about political asylum, so don't expect any good news from me. You applied for asylum based upon the fact that you are gay, and now you're getting married to somebody of the opposite sex. Will USCIS understand that sexuality can evolve? Hey, I even don't understand that. So I'm not sure if you can prove it, whether it is through a psychologist's diagnosis or whatever way you can. I don't know anything about asylum, but if you can prove it's a valid marriage, I think it could work. And how about firmly resettled in a third country? I don't know anything about asylum laws. So I'm not going to be able to help you much. You need to talk with somebody who practices in the political asylum area. Okay, good luck. We go on to the next question. Switching employers while EAD AP combo card is pending. My I-140 is approved. 485 has been pending 180 days. Good. Submitted petition for EAD AP in October last year. Only receipts are there. What happens to EAD AP if I switch employers? Well, first of all, are you going to get a new H1b? If you are here, press *5. I want to talk to you. because your questions are not clear. Okay. Area code 281, where are you calling from? Hello? 281? Hello?
Hello.
Where are you calling from?
Can you hear me?
Yes,
sir?
I can. Where are you calling from?
I'm calling from Houston.
Okay. So, real quickly, this is your question. Did you post it?
Yeah, I posted.
Okay. So, tell me,
Yes, sir.
you said you're going to change employers. Are you going to transfer your H1b?
H1, sir.
Okay.
Yeah.
So, that's no problem at all. You can, and the fact that you changed creates no effect on your EAD or AP. No problem. Okay.
Okay, so we will still be receiving it?
Yes, sir.
Right.
Yes, sir.
We don't have to reapply?
Yes. I hope you're not changing your address. Are you changing your residential address?
I don't want to change my residential address.
Then there is zero problem. You can go ahead and change. If you are using an
Okay.
H1B to change, go ahead. You are fine. You'll get your AP and your EAD. Also talk to your lawyers about doing a supplement J. Okay.
Okay.
Good luck.
And he doesn't have to, I mean, the new employer attorney doesn't have to start from scratch.
Oh, no. Not at all. As long as the jobs are same or similar, they do not have to. No problem.
Mm-hmm.
Okay.
Okay. One last question, sir. Coming back to RFEs on EAD or AP. If I get a RFE after switching jobs, while they are still in pending,
right?
Who will receive the notice? Because
your lawyers.
I will be with the new
your
attorney.
lawyers. Your lawyers. They actually send a copy to the employee also, but your lawyers. This is nothing to do with the employer. This is between you and your lawyers. Okay.
Okay. Thank you, sir.
Good luck. Area code 704. Where are you calling from?
Hello, sir. I'm calling from North Carolina.
Yes, ma'am.
And I have a question, similar question.
Okay.
So I am in the same situation as the previous person said.
Okay.
And I'm planning to file for a supplement J.
Okay.
But you said that supplement J won't be a problem if the job is same or similar.
Yes.
So what is mean by same or similar?
Well,
It need to have SOC code same?
No.
Or I will just tell you my situation quickly.
Okay. Okay, go ahead.
Yeah, actually, I am working as a test lead now with the code 15153.
Don't give me the code. I know what a test lead is. Keep going. Yeah.
Yeah, so I'm getting a new opportunity as a FTE with a good bank, but the role is a Scrum Master role.
Okay.
So both are associated with IT.
But hang on. Stop. A Scrum Master is not a job. A Scrum Master is a role associated with the job. What would be your job? Would you be still doing QA?
No, I won't be doing a QA. I will be doing a project manager or Scrum Master role.
Okay.
So the role and responsibilities will be little different.
Now look,
it won't be testing.
I'm going to make a guess here because the job titles don't matter. It is the job description that is important. This sounds just like a promotion, and promotions are okay. They are considered to be same or similar. Okay. So
do I need to be doing testing in my new role also when I switch to a new employer?
Again, listen to what I just said. I'll repeat it one more time, but then I won't repeat it. I said your job at the bank appears to be a promotion. And the promotion is considered to be same or similar. Why? Because your previous job prepared you for the new job. So, but it is not something I would like to bet upon. Your lawyer should compare the two job descriptions. Job titles don't matter. Job descriptions are the most important thing. But generally speaking, it looks okay to me. Okay? Good luck.
Okay, sir. Thank you.
You're welcome. Area code 608. Where are you calling from? Area code 608. Okay. Let's go on. Area code 281. Are you still on the line? I thought I just answered your question. Okay, maybe not. Okay. Next question. So H1b visa stamping in India. I'm a student on. Guys, I'm not gonna go back to questions that I've already answered. Sorry. I'm a student on F1 visa and my H1b is selected in this year's lottery. Okay. I'm filing my H1b using premium processing, and considering my H1b is approved before June 2021, will I need to get my H1b visa stamped before returning to the US? Okay, this is complicated. If you go to my blog and you read up on travel, I have covered every possible situation. So if you are on OPT and you travel, if you are on STEM OPT and you travel, if you have an H1B registration done but not filed yet, the H1B, you can travel. I've covered every possible situation. The general rule is, if you travel and re-enter before your H1B is filed, you should be okay as long as you are complying with the OPT, STEM OPT requirements. Your DSO can tell you that. Number 2, if you file an H1B and it's still pending, you shouldn't travel, because traveling would abandon your change of status, and that's problematic. If your H1B is approved and you travel and return before October 1st, you should be okay as far as I know. But if you get the H1B approval and you want to come back after October 1st, you got to get your H1B visa stamping done. That's the normal rules. Any follow-up questions? Press *5. Press *5. Any follow-up questions? Okay. Question number 17. Filed I-140, 485, everything together, downgrading. Tried to submit I-140. Oh, yeah, I think I already covered these. The USCIS returned the petition saying we cannot file premium for downgrade. Yeah, I already covered this question earlier, that they need the original PERM application. Yeah, keep trying. That's what the other guy was doing. Okay, so yeah, you can keep trying if you like. I have I-140 approved for EB2, and now we have filed petition for EB3 downgrade. When can I change my job? After the I-140 approval and your 485 pending 180 days. So you don't have to go through all this again if you meet the requirements of AC21 portability, which means your I-140 is approved, which is the downgrade, and your 485 has been pending 180 days. Can the approved I-140 for EB2 be considered and ported to EB3 to change the job afterward? No. If the dates become current for the EB2, that's different. But you can't do that. You can't change like that. You have to wait for the EB3 I-140 approval to use portability of the job through the EB3 I-140 downgrade. *5 if you have a follow-up question on this. *5. Okay. Area code 203, I think, is Connecticut. Connecticut, go ahead.
Hey, I just have a quick question. Thank you for your suggestion. We have filed my and my wife's petitions together, but since we had her biometric last year, they considered that, and they considered that on the EAD application.
Okay.
So, is it necessary that my EAD needs to be approved before her, or
no,
she can get her approved?
She can get hers approved first, no problem. Okay.
Okay.
Good luck, sir.
Okay, thank you so much.
You're welcome.
Thank you.
Okay. This is the last question for today. Guys, much though I would like to help, I don't have time for new questions. If your question is extremely urgent, connect with me on LinkedIn. I'll try to answer it there. over the next day or two. But right now I don't have time. I've got to get back to work. The last question is, so he wants to get married when she is visiting the United States. Due to the pandemic, I can't travel back home. If she comes here on her B1, B2 visa, is it possible to register? Don't say register, say get married. Yes, you can get married here on a B1, B2 visa and then go for H4 stamping. Yes, you should not do a change of status, because if you try to do a change of status from B2 to H4, unless that intention is declared at the airport, the government can say you have misused the B2 visa, and that's fraud. Don't do that. Another option would be, since I'm a Canadian permanent resident, can she come to Canada on a visitor visa? Yes, absolutely. That would be a great option. If she comes to Canada, you get married there, apply for her H4 visa at the US consulate. Absolutely. That's much better. I don't know what the situation with the visas is going to be, guys. I'm a little pushed for time, so I'm going to have to skip that question. Star 5, if you have a follow-up question on this, star 5. Okay, area code 614. 614, where are you calling from?
Yeah, Rajiv, I'm calling from Ohio.
Yes, sir.
Yeah, so that was my question. So yeah, I agree with you. I'll definitely make sure that the intention doesn't get misinterpreted for her purpose of B2 if she comes here, because yeah. So let her go either to Canada or to India, and then tell clearly that she came here and she got married, and now she's asking for a H4 again, right?
Yeah.
Okay, her marriage certificate will show that it is from US, so that should be
No,
fine,
that's
right?
allowed.
I heard about
You know,
90-day.
hang on. Let me split this up for you. So, situation number 1, she travels to USA on B2 visa. You guys get married here, and she goes back for her H4 visa, either to Canada or to India. Perfectly okay. Okay, because she's not applying for a change of status to H4.
I see.
Situation number 2.
I agree.
Situation number 2. She travels on a tourist visa. She enters. You get married. She tries to convert status within USA. Problem.
Okay, I see what you mean.
Okay.
And then I read on the USCIS website about the 90-day rule that typically they follow.
No, don't do that. That 90-day. No, don't do that. They can extend that rule all the way to 6 months, because just because you skip 90 days doesn't mean they are not going to hold you responsible. Do not do this. Do not.
Correct. So I'm definitely following your advice and not going to go with the change of status option.
Absolutely.
But even with the first option, I was asking is should the marriage happen after the 90 days?
The
marriage,
marriage can happen the very next day. I don't see any problem with it. Okay.
Okay. I see what you mean.
Yeah.
And as long as she goes back.
Yeah. The only thing I'm concerned about is, what does she answer when she's questioned by the USCIS, the CBP officer? She should tell the truth. She should say, I'm getting married and I'm getting out of here.
Okay, and then coming in the right status.
Absolutely.
Right?
Absolutely.
Okay, so she should be upfront about it.
She should be. And another thing you can do is, just because there's a possibility CBP could be real jerks about it and say, no, you can't come in, you could ask her to come for a flight, through a flight that does immigration clearance in Abu Dhabi.
Oh, pre-clearance. I got you. I have done that. Yeah.
So do it through pre-clearance. That way, if she's turned back, she's only got 3 hours. What is it? 2 hours, 3 hours to India from Abu Dhabi?
Yeah. Okay. Yeah. I'm hoping that doesn't happen, but anyway, because as they should realize the situation that
absolutely,
we are not here, that we can sponsor
and you can tell them that you've been advised by counsel that you're not allowed to change status, and you're not going to do that. You're going to go for visa stamping. Okay.
Correct. Right. I get you. All right. Then.
Good luck.
Thank you for that.
Good luck, sir.
Yeah, and obviously, my other part of the question, I guess you should probably do a section about
that. I've got that's there's a whole lot of information there that I need to go through. So don't have time today. We can talk about it some other time. Okay?
I absolutely agree with you. Yeah, sure. We will just wait for your separate session for that.
Yeah, because the way the visa numbers are counted is quite complex. So 1 year they do the spillover from employment to, but never has been done. But 1 year they do the spillover of the visas from family-based to employment, and I don't even remember the exact formula. Only 7% of the total numbers can go to one country. You can only issue X percentage of that in 1 quarter. There's all these rules that will drive you crazy once you start looking at them. So I don't know the answer off the top of my head. Okay. Good luck.
Okay, no worries. Yeah, thank you. Bye.
Okay, so this is the last question for the day. Re-entry through a U.S. consulate in India in length of renewal. I'm working in India for an Indian subsidiary of a U.S. headquartered company. My re-entry permit expires on 20th June. My first re-entry permit was valid, but I moved to India. I've been working in India. I came to USA to file I-131. Okay. Can I do the re-entry application process through a U.S. consulate? No. But you can apply for an SB1, returning resident permit, if you cannot come to the United States to do another 131. Do I need to come to the United States 2 times like I did in 2019? Yes. I think the first 4 years they give you 2 years each. After that they start doing it 1 year. That's supposed to be the normal policy, but I know that they sometimes even exceed that. So first 4 years they should give you 2 years, 2 years. Other extensions could be 1 year, 1 year. Okay. *5 if you have a follow-up question on this. *5. Okay. Very good, guys. I will see you again in 2 weeks. Good luck.